Hi everyone, good day. I am Vian Limas from Base HM3B, and today I am going to report Chapter 4, Law on Partnership and Corporation. So our learning objectives differentiate the various kinds of partnership and corporations and responsibilities and partners and incorporators. And second is identify the requirements in the formation and resolution of partnerships and corporations. So, startup operation must have a strong foundation, and in order to have a strong foundation, you must start with a strong business organization. So, it means forming a partnership of a corporation is a better choice in forming business organization in order to enter a competitive industry, so like the tourism industry. So, this chapter, we will present an overview of a partnership and corporation as a business organization. So, the law on partnership is governed by the Civil Code of the Philippines, while the law on corporation is governed by Batas Pambansa, Corporation Code of the Philippines. So, the law, Article 1767, so by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. A discussion of the law. So the definition of a partnership does not include religious associations, conjugal partnerships, and other of a similar nature because of a partnership is defined by law. So a partnership contract is based on trust and confidence, refers only to associations, the purpose of which is to obtain profit to be distributed among the partners. So the essential requisites of a partnerships are first is an agreement to contribute money, property, industry to a common fund. So this complied with if so each one of the partners brings or is obliged to bring something to the partnership. And second is that which is brought becomes common property. Then second is intend to divide the profits among themselves. So it is complied with if partnership is established to obtain profits. Profit must be common to all the parties. And last is profit or loss must be divided among the partners. So advantages of forming a partnership. So first is easy to form. Second, improved growth possibilities. Third is freedom from bureaucracy. Then the disadvantage of forming a partnership is first is instability. Second, difficulty in obtaining large sums of capital. Third is firm is tied to the act and judgment of one partner as agent. Then lastly is difficulty is severing partnership ties. So classification of partnership. So first is according to subject matter. So we have universal partnership. So a partnership where all of the partners contribute all of their properties to the common fund and speaks of no particular purpose or subject matter. So as long as the purpose is forming a partnership, it's to obtain profits and it's not contrary to law, morals, public order, and public policy. Then second is particular partnership. So it has for its object determined things. So their use of fruit or a specific undertaking or the exercise of a profession or vocation. Then the second classification is according to liability. So we have general partnership. So composed of general partners where liabilities extend to their personal properties. Then limited partnership. So it usually attaches the word LTD or limited. So at the end of the company name. So one formed by two or more persons having as members one or more general partners and one or more limited partners. Then the third classification is according to duration. So we have partnership for a fixed term. So it is one in which the term of its existence has been agreed upon expressly or impliedly. So it means the expiration of the term thus fixed or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. So, a partnership can be in any form. So, even if not recorded at the Office of the Securities and Exchange Commission, so except first is when it is stipulated, second is when immutable property or real rights are contributed. So, in which case there must be a public instrument to which is attached an inventory of the immutable properties and signed by the parties. So otherwise, the partnership is void. Then third is, in the case of a limited partnership, the parties must first is sign and swear to a certificate which shall state among other the name of the partnership, adding the word limited and the character of the business. Then second is file for the second the certificate in the Office of the Securities and Exchange Commission. So, obligations of the partner. So, we have first contribution is money or property. So, if a partner promises to contribute money during the celebration of the contract and he fails to do so, so it means he shall pay the interest and damages from the time he should have complied without need of any demand. Then second is where contribution is industry. So an industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. So the capitalist partner may either exclude him from the firm or avail themselves of the benefit which he may have obtained in violation of this provision with right to damages in either case. Then the third is obligation of the capital partner. So a capitalist is prohibited from engaging in a business in competition with the partnership unless there is a stipulation to the contrary. So otherwise, all profits of such partner belong to the partnership and all losses shall be for his account. Then the fourth one is the responsibility between partnership and partner. So the partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership. So it means it shall also answer to each partner for the obligations he may have contributed in good faith in the interest of the partnership because and for risk in consequences of its management. Fifth is sharing of profit and loss among partners. So the distribution of profits and losses shall be in conformity with the agreement. So if only the share in the profits is agreed upon, so the share in the losses shall be in the same proportion. Then the sixth is property rights of a partner. So a partner assign his right with respect to the specific partnership property for one partner's individual debts or for legal support. So it means the right to participate in the management is governed by stipulation of the partners. So if none, all of the partners participate in the management. Then seventh is liability of individual partners to third person. So all partners, including the industrial partner, are liable pro data will all their properties for contracts with third persons provided. Then the last is liability of the limited partner. So a limited partner as a general. Dissolution and winding up of a partnership. So the law. Article 1830, dissolution is caused first without violation of the agreement between partners. So it means by the termination of the definite term or particular undertaking specified in the agreement. So by the express will of all the partners. Then by the expulsion of any partners for the business bona fide. Then the second is in contravention of the agreement between partners. Third is by any event which makes it unlawful for the business of the partnership. So, and fourth is when a specific thing a partner had promised to contribute to the partnership. Then, fifth is by the death of any partner. Sixth is by the insolvency of any partner of the partnership. Then seventh is by the civil interdiction of any partner. And the last is by the decree of the court under the following article 1700A and 1701A. So discussion of the law. So in the case of a limited partnership, the same is dissolved. So first, in case of retirement, death, insolvency, insanity, or civil interdiction or a general partner. Second, when asked for by a limited partner under the provision Article 1857. So civil interdiction. So civil interdiction is defined as an accessory penalty for the commission of an offense. So in which deprives the offender during the time of his sentence of the right of potential authority. Then insolvency, so it is defined as a financial condition in which one is unable to meet his obligations as they mature in the ordinary course of business, or in which one's liabilities exceeds his assets at any given time. So order of liquidation for a general partnership. So the law. Article 1839. In setting accounts between the partners after dissolution, the following rules shall be observed to any agreement to the contrary. So, first is, so the liabilities of the partnership shall rank in order of payment as follows. So, we have those owing to creditors other than the partners. So, those owing to the partners other than for capital and profit. C is those owing to partners in respect of capital, and last is those owing to partners. So discussion of the law. So take note that the liquidation process under the above provision applies only to a general partnership. So there is a different process for the liquidation of a limited partnership. So order of liquidation for a limited partnership. So the law. Article 1863, in settling after accounts after dissolution, the liabilities of the partnership shall be entitled to payment in the following order. So first is we have those to creditors in the order of priority as provided by law. Second is those limited partners in respect to their share of the profits and other compensation. Third is those to limited partners in respect to the capital of their contributions. Fourth is those to general partners, then for capital contribution. Fifth is those to general partners in respect to profits. And the last is those to general partners in respect to capital. So, discussion of the law. So, the above provision expressly provides for priority in the distribution of assets after dissolution of a limited partnership. So, those due to creditors under number 1, Article 1863 are the outside creditors, including those owing to the limited partners. So, we have Article 1, Subscription, issuance and transfer of shares. So, Section 1, subscription, subscribers to the capital stock of the corporation. Then, Section 2, certificate. So, each stockholder shall be entitled to one or more certificates. So, Article 2, meeting of stockholders. So, we have Section 1, regular meetings. Section 2, special meetings. Section 3, place of a meeting. Section 4, notice of meeting. Section 5, quorum. Section 6, conduct of meeting. Section 7, manner of voting. And Section 8, closing of transfer books of fixing of record date. Then we have Article 3, Board of Directors. So we have Section 1, powers of the board. Section 2, election and term. Section 3, vacancies. Section 4, meetings. Section 5, notice. Section 6, quorum. Section 7, conduct of the meetings. Then Section 8, compensation. Then Article 4, officers. So we have Section 1, election or appointment. Section 2, chairman of the board. Section 3, President. Section 4, the Vice President. Section 5, the Secretary. Section 6, Treasurer. Section 7, Term of Office. Section 8, Vacancies. And Section 9, Compensation. Section 5, Office. So, Section 1, Office. The principal office of the corporation shall be located at the place stated in Article 3 of the incorporation. Then we have Article 6, Audit of Books, Fiscal Year, and Dividends. So we have Section 1, External Auditors, Section 2, Fiscal Year, Section 3, Dividends. Article 7, Amendments. So Section 1. So amendment, so this law may be amended or repealed by the affirmative vote of at least a majority of the Board of Directors. Then the Article 8, the seal. So we have Section 1, Form and Inscription. So the corporate seal shall be determined by the Board of Directors. Then the last is Article 9, the Adoption Clause. So, corporate liquidation. So, after the dissolution of the corporation, it continues to exist as a body corporate, but only for the purpose of enabling it to settle and close its affairs, but not for the purpose of continuing the business for which it was established. So, it means a dissolved corporation cannot extend corporate life during 3-year liquidation period by amendment of its articles of incorporation on extending corporate term. So that's all on my report on Chapter 4, Law on Partnership and Corporation. So I hope that you've learned something. Thank you for listening and God bless.